Hello.
Oh, hi Mark. Glad you were able to connect. We could see you there on the attendees, but couldn't see if you had joined. So I've just sort of started letting everybody in. So we'll just wait sort of a minute or so to let everybody filter in, and then I will kick off with a short presentation. Um, cool.
Mark, you appear to have joined twice.
Do I?
Yeah, looking at the list at the top, it says Mark Watson Gandy, James Batterson, Mark Watson Gandy.
It because I'm dialing in from Ghana, so I
Ah,
was trying a number of connections.
yeah.
Very glamorous.
Mhm.
I can only see you once, like actually on the video, so I think that's probably
And once is more than enough.
Yeah, no, it's
your
just if
words,
you,
your words.
yes, notice if you move along the little icons at the top, you may be able to
Yes.
see Mark's name twice.
Yes, yeah. Okay, great. So
Mhm.
I think we'll probably get started. So thanks very much for coming, everybody. Hope you're having a good evening. So what we've got on the agenda tonight is a great insight online event. Looking at kind of becoming a barrister, but specifically around getting into commercial and or chancery law. So I'm going to kick off with a little bit of housekeeping first. So if I can move my slides along. So I'll kind of talk for maybe 10, 15 minutes, do a little bit of housekeeping, kind of touch on a few key points that we'd like to cover at these events. Just to say that if you have attended one of our Insight events before, this presentation will be a little bit of a repetition, hopefully perhaps just some reinforcement of things that you've already been told. But hopefully it's all kind of helpful. And then we'll get on to the real reason why everybody is here, which is our panel discussion with our panel of practicing barristers who are practicing in the areas of kind of chancery and commercial law. And then we'll open it up to questions as well. So you'll see probably at the bottom of your screen a Q&A box. Please do feel free to put questions in there. You can ask them while everybody is speaking. That's totally fine. Either I will answer them just in text format while we're going if they're relatively simple, but if they would be better served by a discussion from the panel, we'll save those to the end and hopefully get around to answering quite a lot of questions. So we like to touch on a few kind of key points about the profession as a whole. So what kind of being a barrister entails. So you'll hear, I'm sure, from our panelists about the fact that they think of this as a career that's really rewarding, not to mention intellectually stimulating. All of the barristers who speak at these events love their job. Yes, there are probably really difficult parts of their job, but they wouldn't kind of sit through those hard bits if they didn't really enjoy what it is that they do. And so that is something that can be really appealing about the profession, that you feel like the work you do matters and that it sort of works your brain as well. Those self-employed barristers will often speak of a flexibility that's rarely found in other professions. So we do have 4 self-employed barristers on our panel tonight. That's not to say that there are no employed barristers in commercial and chancery law. Generally speaking, across all practice areas, we're looking at about an 80%, 20% split between self-employed barristers and employed barristers in England and Wales. You do get some employed barristers in this practice area, but it is more common to be self-employed in chancery and commercial law. The important thing to kind of bear in mind, whilst yes, it's a very appealing profession, it does then mean that it's a really competitive and rigorous process to become a barrister, full stop, but it's also an incredibly competitive practice area to go into as well. So speaking more broadly, you're looking at around 500 pupillage vacancies each year. This is, just an approximate number versus around 5,500 for solicitor training contracts per year. Again, approximate figures, but hopefully that sort of shows an indication of the differential there. More people do want to become solicitors, so it sort of follows that there are more spots, but it's important to bear in mind that you're up against a lot of people for not that many spots, relatively speaking. So what we also like to do at these events is just kind of make sure everybody is on the same page, because lots of you may well be at kind of different stages of your academic training or even vocational training. And so we want to make sure everybody's on the same page and coming at this from the same point of knowledge. So in order to become a barrister, you need a degree of some type. It is a graduate-only profession. So that can be a non-law degree plus the graduate diploma in law, sometimes called the PGDL, MA Law, a conversion course, usually 1 year if taken full time, or an undergraduate law degree. So yeah, you don't need an undergraduate law degree necessarily for the profession. You can then also pursue further study if you want, but it's not required at that stage. You then move on to the vocational stage, which is broadly your bar course. Used to be called the bar vocational training course, the bar professional training course. Lots of different names, lots of different acronyms. We now kind of just call it the bar course to keep things nice and simple. You'll do that with an education provider, usually a university, although the Inns of Court College of Advocacy is also a provider of the bar course and doesn't do anything else. But you might go with a provider like someone like BPP, ULaw, City, Cardiff, UWE, for example. And then you have qualifying sessions with your Inn of Court alongside that. And this typically takes an academic year, so autumn to summer, if undertaken full time, although that kind of part-time provision, so doing the course over 2 years, is becoming more common, as well as splitting the course into a part 1 and part 2 that can be done over quite a much longer period of time. So it's important to kind of look into the type of provision that you think would work for you. After you pass the bar course, you've done your qualifying sessions, you are then called to the bar, and that is done by your Inn of Court. And at that point, you get the title barrister. However, you are not a practicing barrister at that stage, even though you have that kind of protected title, that role of barrister. You need to undertake a year of work-based training, which we call pupillage. And so that is split into a first 6, basically 6 months shadowing, practicing barristers, and then a second 6 where you are on your own feet, practicing perhaps in court, dealing with clients, billing clients as well. Some people will then undertake a third 6, either at sort of a different organisation, chambers, than the one they did their first and second 6 with, sometimes with the same, just to sort of top up the training a little bit, before they then obtain tenancy, which can be essentially a position for life, although some people do move between organisations at that stage as well. So that last bit, pupillage, is the particularly competitive bit. There are lots of bar course places out there, and while you have to apply for them and interview for them a lot of the time, they are not as competitive as obtaining pupillage. In terms of how to get pupillage, we'll touch on a little bit of stuff here, but perhaps our panelists will also speak to some sort of helpful advice, how they manage to do it, how they see people across the other side of the table now as those who are part of pupillage selection committees. It is important to be realistic. 97% of people who are successful in obtaining pupillage have a 2-1 or higher, so a 2-1 or a first in their undergraduate degree or their law conversion course. Sort of latest statistics in specifically sort of chancery law and commercial law, far more people who obtain pupillage have a first, and so that does differ between different practice areas. So that is important to kind of bear in mind, that sort of evidence of academic and intellectual rigor is quite important for this practice area. That's not to say that you shouldn't bother if you don't get a first, but you need to think about how you're going to demonstrate those skills if you haven't kind of demonstrated it through your academic achievement. It is really important to be determined and to be resilient. If this is a career path that you are really intent on, at points in that journey, and even once you're in the profession, you will fail. It is a part of the role. You can't win every case. Unfortunately, it's not TV, and so you're not going to win every case, and that's just the reality. How do you deal with failure? How do you deal with setbacks? You need to kind of think about whether or not that is something you are prepared to deal with if you're intent on pursuing this profession. I myself am not a barrister. This is not a career path that interests me. Part of that is because I'm not a fan of failure. In my personal life, I'm a Spurs fan, so I deal with enough failure as it is. I don't need that in my professional life as well. Work experience is a really valuable asset when you are sort of looking to go down this route. And part of that is doing a mini pupillage. Many commercial and chancery sets will require you to do a mini pupillage before they'll consider an offer of pupillage. And so that is a little bit different, again, compared to some other practice areas. Not all chambers will do that, but it is something to bear in mind. And that process can often be assessed as well. So there's a task involved. And so it's a little bit more formal than perhaps some mini pupillages at criminal sets, for example. We do understand that mini pupillages are also difficult to get. Perhaps they're more competitive than pupillage. And so there are other ways to demonstrate your experience and your skills. And so that can be highlighted through additional work experience, whether that's voluntary or paid. Maybe you work in the student union bar over the weekends and you have to deal with a lot of drunk customers and their students as well. And so maybe that's quite challenging for you. How do those interpersonal skills, those communication skills, translate to a career at the bar? Probably a lot better than you might expect. And so what we would always encourage, particularly when it comes to scholarship applications, is to really think about the experience and the skills that you bring, whether or not those have been gained in a legal context or not. But it is also worth considering things like mooting and debating, mock trials, and engaging in that kind of legal advocacy, because sometimes that can be a really strong way to demonstrate that you have those skills, that you could be a good barrister. So scholarships are one of the big kind of things that we want to promote as one of the Inns of Court. So all 4 Inns of Court offer scholarships. The bulk of our funding goes on bar course scholarships. Those of you who've had the misfortune to look up how much the bar course costs will know that it can cost up to £20,000. And so just being able to, come up with that money yourself is pretty challenging. Unless you combine the bar course with an LLM, so a master's, you can't access postgraduate student finance if that's something that you're eligible for. So you really do have to come up with that money yourself. And even if you are going to take out a postgraduate student loan, you should be sort of aware of those repayments and how that will impact your future life, and how taking on that debt, even if it's not necessarily considered debt in the traditional kind of concept, it is still a big financial undertaking. So we do want you to consider the Inns of Court scholarships. They are also particularly prestigious as well. So when it comes to pupillage applications, they can be a real kind of feather in your cap. So we in a temple offer around £2 million each year in scholarship funding. Most of that goes on bar course scholarships. Scholarships across the inns are awarded on merit first, so how well you perform on the application form and the interview, and then how much you get is means tested. So if you were judged to have the minimum amount of financial needs, so you're financially well off, but you got the scholarship, in a temple, the current amount is £3,000. The maximum, if you were judged to have the maximum amount of financial need, is £20,000. So it makes a big difference, and we would really encourage you to apply for our scholarships if you are able to. So we do currently interview everybody who applies for a scholarship. So for our bar course scholarships, sort of the round that's just passed, we interviewed just over 500 people for our bar course scholarships. To be perfectly honest, we were really pushing up against capacity, interviewing that many people. So it's important to keep an eye on our website in case any changes to the process are made. But depending on which inn you fancy applying to, that's where you should check for the most kind of up-to-date eligibility criteria, assessment criteria, and that kind of thing. We all broadly offer a similar service, and so we're certainly not in competition with each other, and we want you to apply to the inn that you think you've got the best chance of success at. So the criteria are really crucial to the application form and the interview, and those criteria in a temple are academic performance, advocacy potential, legal comprehension and reasoning, professionalism and interpersonal skills, and motivation to pursue a career at the bar. Those are the 5 criteria for bar course scholarships, and so pretty much everything relates back to those. Obviously, kind of more information about the criteria can be found on our website, along with sort of deadlines as well. The important thing to bear in mind is that you basically have to apply an entire year in advance of when you're going to start the bar course for our bar course scholarships. So this autumn, when applications open in mid-September and close the first Friday in November, the people who are applying will be looking to start the bar course in sort of September, October 2026. So you have to think quite far ahead in advance. We also offer GDL scholarships, so applications for those have just closed, and those are for people starting this September, so slightly less far in advance. And those, again, are kind of the same period each year. So this event in particular is focused on getting into sort of commercial and chancery law, and so I thought it might be helpful just to highlight what commercial law is, what chancery law is, what's the difference, what makes them similar. Now, I don't come from a law background myself, so to be perfectly honest, I Googled this, I added it to the slides, and then I emailed our panelists and said, does this look right? Is there anything obvious I've forgotten? And then, as is the case with many commercial and chancery lawyers, I got lots of emails back, lots of debate about what to include, what not to include. Oh, should we do this? Should we do that? And so that kind of attention to detail is really important in this area of law. And so I've included a few things here, but our panelists are also going to touch on it a little bit as well, because of course, when you're working within a certain practice area, you won't necessarily do everything that is kind of under that umbrella. You might do a bit of commercial, a bit of chancery. You might only do contract law. You might only do shipping or tax or that kind of thing. So sometimes people really specialize and sometimes people have a broader practice. So I'll leave it to our panelists who actually know what commercial, or say they know what commercial and chancery law is, to kind of cover that. But just to make sure we're sort of on the same page and you aren't thinking that we're going to be talking about murder trials for the next hour and a half or so. Okay, Rahul, I think that's quite enough talking from me. So please feel free to take over and just completely disagree with everything on my slide.
Thank you, Jess. Hilariously, I'm chairing a panel comprised exclusively of more successful barristers than me. So I'll quickly introduce them before I try and give a broader distinction between chancery and commercial. So after I'm done introducing, we're going to hand over to Harriet Holmes, who's a barrister at Wilberforce Chambers. We'll then hear from David Grant KC of Outer Temple, and then Mark Watson Gandhi of Three Stone Chambers and Lincoln's Inn, and then I'll finish. You will have seen on the slide a fairly detailed explanation of what commercial and chancery are. I'll try to put it in slightly broader terms because they're fairly opaque terms and not everyone understands them. And then I'll be torn asunder, I'm sure, by my co-panelists as to the definition. Chancery law is the law of the way different legal persons assert ownership over different types of legal property. Some of those legal persons are individuals like you and me. Some of them are abstract entities like a company or a limited liability partnership. But chancery law is fundamentally about the way in which those legal persons assert their rights over different types of property. And some of that property is tangible, like real estate or a classic car, and some of it is intangible, like intellectual property, a pharmaceutical patent, or the melody to a song. But what we are arguing about is the way in which those different legal persons assert their rights over different types of property. Commercial law is the law of transactions between businesses. And of course, some of those transactions involve the buying and selling and acquisition of interests in different types of property. And the ability of businesses to acquire property or dispose of property is sometimes limited by their status as legal persons at that point in time. And so for that reason, chancery and commercial law tends to find itself lumped together in reality or in practice, perhaps more than would be immediately apparent just by thinking about it in an academic sense. So with that very broad definition of chancery and commercial in mind, can I hand over first to Harriet Holmes to introduce her own journey to the bar?
Thank you so much, Rahul, and good evening, everybody. May I just add before I start my introduction that I think that was a very fair and well put explanation of the distinction, and we can talk to you more about it, how that plays out when you're thinking about applying to chambers and trying to work out what work commercial sets and chancery sets actually do, because they all look a little bit different sometimes, or at least market themselves in particular ways. So perhaps those of you that want to know more about it can put things on the Q&A. Right, in any event, then to say hello, my name is Harriet Holmes, and I was called to the bar in 2011, qualified effectively in September 2013, and ever since have been practicing as a land lawyer. So to talk to you first about my sort of path to the bar and how I ended up getting to the set I'm in and the work I do. There's the way I tend to describe it is that there was some of it was by accident, some of it was by design. So the design part is that I chose to go and do a law degree at university, having had interest in reading other things, but not being able to decide between those subjects. And therefore decided that since I wanted a career in the law, I'd go and ultimately read law. I don't remotely regret that choice because I very much enjoyed my degree, but perhaps for those of you who are on this call who are non-lawyers and not being sure whether my fellow speakers are all law graduates themselves, I should just say that in the field of Chancery commercial work, it is certainly not unusual for non-lawyers to convert to the law and then ultimately be able to obtain pupillage in and practice in Chancery commercial work. But I am a law graduate. I then went on from my sort of undergraduate law degree to do a master's, perhaps slightly unusually in an area that is nothing to do with what I do in my day-to-day. I had an academic interest in public law and human rights, and sort of rather as a I guess a luxury when university tuition fees were much lower than they are today, I went off to go and spend a year thinking in more detail about particularly constitutional law, which I found particularly interesting. So that might seem a rather odd start to a legal career that ultimately ended up in land law. And this is where, again, there is an element of accident and design. The design is that I knew I didn't want to be a public lawyer, and I knew I didn't want to sort of practice in human rights. As I said, it was an indulgence really for myself to go off and indulge my academic curiosity in that field. And so I'd started at the point at which I was in my final year of my undergraduate degree to really try to hone and understand better which areas of law I might ultimately want to end up practicing in after I'd finished my academic study. And what I'd realized is that I particularly liked the subjects of contract law, equity and trusts, and land law. And that's what I'd really enjoyed during the course of my undergraduate degree. And so I started to think about and indeed applying for sort of mini pupillages to undertake during my master's year, just to get a real sense of what different areas look like in practice. And that included doing mini pupillages. I even did one sort of criminal mini pupillage just to be sure that that was something that I wasn't terribly interested in. But as I went through the process of doing mini pupillages, I realized more and more that actually it was the sort of property law that was particularly interested me. And this is where the accident comes in, because simultaneously I was doing voluntary work in a law centre dealing with principally legally aided cases, helping a solicitor who was dealing with legally aided cases, I should say, in the field of housing law, where there's the sort of crossover between public law and certain sort of aspects or principles of landlord and tenant law. And I realized that having not enjoyed the public law component, it really was the sort of the landlord and tenant and ultimately landlord areas of that work that interested me. So my focus really did start to move towards land law. But having been told that it's good to keep one's mind open, I sort of applied to sets that I thought I might be able to obtain a pupillage in, and they were sets that had a mix of practice areas, including property law. I obtained pupillage whilst I was on the bar course and went to practice in a set that, not my current set, a previous set where I could have done exclusively and did do exclusively property law in practice. So that in a nutshell is the sort of the accident and design element of what resulted in me getting to pupillage, and then I got into my previous chambers. To sort of complete the story and how I ended up where I am now, I spent a happy first few years of my life as a tenant in chambers, practicing in land law, and essentially was approached by the chambers that I'm a member of and asked to consider applying, which I then did do. So that kind of brings me to the question of, what does my day-to-day look like? Well, as a land lawyer, I started out doing lots and lots of possession actions, traveling all around the country, going to county courts quite literally all around the country, dealing with matters like getting possession orders instructed by a bank that was seeking to enforce their security, the mortgage, or things like forfeitures of leases. There were all sorts of things that would have given rise to the possession claim, trespassers and the like. And I did that a lot, and I was in court a lot and very regularly. Simultaneously, I started to develop a practice that was to do with the development disputes that relate largely to the development of land or rights and ownership relating to land. That can cover so many things. There is no typical week. But what I can say is that as my practice has gone on over the last 10 years and I've got more senior, I'm not in court as much as I used to be, and I quite like that. So my practice looks like a practice that does get me into court on my own feet as well as when being led by a silk. But so I have a good mix of led and unled work. But as I've got more senior, the cases that I'm working on have got more complex, more and more cases settle. And so I'm certainly not in court as much as I used to be. But as I said, there is the opportunity for that. And I enjoy it because I like legal problem solving. I like thinking about complicated issues. And I get to do that every day when I'm dealing with clients in an advisory capacity, or drafting a skeleton argument or some other document that's going to go to court. And then eventually certain cases go to court and I get to do that too. So I enjoy my practice because it is varied. I deal with lots of different disputes. I'll give you an example of this week. Tomorrow I'm going to go to do a site visit at a property that is in central London, where there is a prospective dispute with a landlord that relates to development of the airspace above a building. And the tenant themselves are sort of in the process of refurbishing, and that process has resulted in a dispute with their landlord. But then today I was advising in a conference on issues that relate to a pending application to remove my client as a registered proprietor of some property, and so another party has made an application to Land Registry to remove my client as the proprietor, and so I was working out whether there is a basis on which to do that, or indeed whether the Land Registry should be refusing that application. And then later in the week I will be looking at something that is all about a development in the City of London, and whether an injunction should be granted to prevent somebody developing property which neighbours my client's land, because that development will reduce the amount of light that is enjoyed by my client's properties. That's what we call a right to light dispute. So you can already see, giving those three examples, that even though land law is a sort of particular area within a much broader area of work called Chancery commercial law, my practice looks very varied and can involve dealing matters on my own, or indeed bigger cases with silks as well. Before I sort of hand over to the other members of the panel, who will probably have much more interesting things to say, we were asked to raise whether we're involved in our own chamber's pupillage selection process, and I indeed am. I regard it as fortunate enough to be the deputy chair of my chamber's pupillage committee, and so I'm very actively involved in pupillage. And indeed was doing pupillage interviews really not very long ago at all. So in terms of what my own chambers, because I can only ultimately speak to what my chambers looks for in pupils, what we're looking for are really three things. The first is all to do with what's between your ears, essentially, an intellectual analytical ability which demonstrates excellence, the ability to really deal with some of the most complicated legal problems that might cross your desk. And we're looking for people who have achieved high academic, they've got high results, good results at their academic stage of training. We also look for strong written and oral communication skills. So that, put quite simply, is the ability to convey information, whether it's in writing or orally, in a simple, clear way. We're usually looking for quite clear, succinct expressions of language using normal, ordinary, plain English, rather than very florid terminology. And then thirdly, the motivation to not only come to the bar, but also to show that you have a particular interest in Chancery commercial work specifically. And those are really the kind of three facets to what we're looking for from our applicants. How people can go about demonstrating that? Well, first and foremost, just do your absolute level best at university so that you can sort of give yourself a proper fighting chance of getting into this area of work. Because as Jess has rightly pointed out, it's competitive and tends to be an area of the bar where good academic qualifications are usually looked for by most chambers, if not all. And then on your application forms, using clear, clean, plain English to sort of answer the questions on the form, or most sets now use the Pupillage Gateway system. And then thirdly, when it comes to sort of job motivation, we tend to say that we don't expect people to have done mini pupillages with us, or indeed to have done many pupillages. What we tend to suggest is that if you've done a mini pupillage, like within Chancery commercial work, whether that's one or a couple, then that gives a clue, combined with your answer to the questions why Wilberforce Chambers, or why this area of law, and why it interests you. So don't, I suppose my message there is, don't be concerned that you may not have 10 mini pupillages or anything of that kind. We tend to look at the application in the round to see whether the individual applicant is sort of demonstrated an understanding of and a real desire to do our area of work. But a mini pupillage, at least in a Chancery commercial set, is certainly a good thing, and will certainly help, at least on our application forms. I'm going to stop because it's better if we get through this section and get to Q&As, but I'm obviously happy to answer any questions later.
Great, thank you. I think with that, David is next.
Good evening, everybody. Thank you, Harriet, for that really helpful introduction. So I was called to the bar in 1999. I took Silk in 2022. I am a Chancery and commercial practitioner, and I will explain exactly what I do in due course. I studied law at university, did a postgraduate in law, taught trusts for a bit while doing the bar course. I had three big decisions I wanted to take, or had to take. One, did I want to practice in Scotland, where I grew up and came from, or in England? Two, if England, London or elsewhere, because I thought London was a ghastly city. And three, if I wanted to do shipping and insurance law or Robert Maxwell's pension schemes. And that was the exact line I said to someone a long time ago. And by a combination of accident design, like the rest, I sort of ended up where I am. I undertook shipping and insurance pupillage at two quite well-known sets. That didn't work out. So I then had to look for other things, other places to go, and came to what is now Outer Temple Chambers. The big draw for me was pensions work, which I thought was interesting. There was going to be a lot of work. It was a nice mix of commercial work and trusts law. And I've done quite a lot of that. When I started off, I did even things like personal injury, family, you name it, up and down the country, like many people have done. But then with time, one's practice narrows. And as I was in the last few years of being a junior, my practice really narrowed, and I was on a few big, long-running cases. Come through Silk, and then the practice areas broaden, and that's not unknown, although sometimes the exact opposite can happen. Stuff I'm doing at the moment ranges from contentious probate cases, which is pure chancery, sometimes awful family disputes, people challenging whether their mother had capacity or was undue influenced by the brother to leave all her estate to them. At the other end, enforcement of arbitration awards, which is pure commercial work in the commercial court. As Rahul said, the first one dealing with individuals, the second one dealing with massive, and in one case, state entities. But there is inevitable crossover. So one arbitration enforcement I'm doing at the moment, all to do with a massive oil gas supply contract. But the defendants didn't pay up. Proceedings have been issued in England to enforce the award. They've looked around, they've found some very valuable property on Victoria Street, close to Westminster Square, which on the face of it, one party owns, but my clients say they own. And it all comes down to Section 53, 1B of the Law of the Property Act. So it's a classic example of the intersection between Chancery and commercial work. And it's interesting to see the people involved in the three parties, some who are undoubtedly at pure commercial sets, some who are at Chancery sets, some who are the people who kind of straddle the division. So it is interesting. Again, with time, my court work reduced in the number of times one's into court. The cases get bigger. I'm involved in one case where after 9 years of a lot of work, we have issued proceedings. You don't want to rush these things sometimes. Clearly, there were no limitation issues, but it's just a function of some of the cases one does. And that's exceptional, and it happens in some areas much more than it does in others. Other people will look with horror. You will never get this in public law or criminal law. You might get it in personal injury law. If you're dealing with children, there's no limitation period. Things are really, really different. And there is no standard practice, and there's no right or wrong thing to do. It's what you like. I always say to people, you've also got to decide not just what sounds interesting in terms of work, but what the reality of the working life is. So some people like being in court all the time if they're a criminal practitioner, and that's great because that's ultimately why most people come to the bar, but it's quite intrusive on your autonomy and personal life. The other end of the spectrum, if you are, say, doing some areas of tax or partnership or whatever, you may be in court much less often. It's remunerative, it's interesting work, but you need to strike a balance. And where that balance is something only you can say what you want to do. Whether you achieve it or not is another question entirely. In terms of other things and my kind of familiarity with pupillages, I've had, I think, 25 or so pupils over a long period of time. I have interviewed pupils for 20 years. Most sets will probably be looking for the attributes Harriet identified, but they will vary slightly in that sets such as criminal sets will perhaps focus less on the written analysis because that plays a lesser part in criminal practitioners' practice. Like Harriet, I'm in the academic liaison subcommittee of the Chancery Bar. I'm also in charge of mentoring. I sit also on the ICCA Chancery Scholarship Panel. So I'm heavily involved, as all four of us are in different ways, in the attraction of new talent and the bringing on of people and the making it accessible. It might be helpful, Jess, if I answer some of the questions which I've seen on the Q&A. Someone's asked, can you get commercial chancery mini pupilages without prior experience in those areas? Yes, you need to start somewhere. Everyone at some point has no experience, and you need to have a first experience. Mini pupilages are the way. Again, I would encourage people to really think about doing different areas of law. It's really useful to go to interview, say, well, why are you convinced you want to come to the Chancery or commercial bar? And you say, well, I did the mini pupilage criminal set, and I hated it. Or I'd spent time in a magic circle solicitor's firm, and that's not for me. It's really useful sometimes having negative experiences, if only to explain why you don't want to do that going forwards. Another thing I would say, and this will be a theme of the talk starting from what Jess said at the outset, sadly, with time, the average age of pupils has gone up and the number of degrees that people have has gone up. When I started 25 years ago, having one postgraduate was exceptional. Now it's almost par for the course in these areas. And I'm sure the others who interview will have seen this phenomenon as well. And again, answering one of the questions someone said about how many recent pupils hold a PhD. We've had a recent flurry in years. Some people with PhDs, my set's a mixed set. We also have doctors who've then seen the light and moved across. But just because you have a doctorate, postdoctoral qualifications doesn't necessarily guarantee that this is for you. Equally, just because you don't have that doesn't mean that this isn't an option. But the reality is it is competitive. I also sat on pupillage interviews recently. My chambers had 2 vacancies and we had 350 applications and we interviewed 50 of them. And the CVs of some of them are really impressive. And that, I'm afraid, is the reality. And it is better for people to be aware of that. And things have changed with time. And that's just that. There's a lot more support out there. When I was in your position, one didn't have these events for lots of reasons. There was no mentoring, there was no support, there was no ready access to information because the internet didn't really exist. But there were far fewer people applying and it was less competitive. So the things balanced to some degree, but not completely. So that's who I am, that's what I do. Hopefully that's given you a bit of an insight. And I'm going to pass over to the next person and then again, willing to answer questions at the end.
Thank you very much, David. Mark. Who's hopefully still with us. I know he's dialing in from Ghana, so possibly, hopefully, is still on the call.
Looks to me like Mark is frozen, so so I would say maybe kind of if we cover some questions for the time being in the hope that Mark rejoins, I will drop him an email just to check in.
Sure. Well, I'll tell you what Jess, why don't I go and do my bit now in that case, and then we can leave questions at the end because Mark might have something to contribute in relation to those.
Yes, sounds good.
Cool. All right. So slightly sooner than advertised, I will explain my own background. And I should start with a confession that will be familiar to Jess. I don't really like doing Journey to the Bar stuff very much because whenever I do it, it sounds really kind of cringy and #blessed. So apologies in advance for this. I'm a first-generation immigrant from India, but I moved to the UK when I was a baby, and I grew up in Southport in the Northwest. And Southport is very much still where I instinctively call home, even though I don't live there, obviously. I went to a church primary school and then a bang average comprehensive school, and just over half of the lads in my year got 5A starter Cs, and then a stage 6 form college. And then I went from there to reading undergraduate law. I ended up becoming a barrister really because whilst I was at my high school, I had an English literature teacher who was a frustrated lawyer. He'd started reading law academically and then switched to English and always sort of regretted it. And because I did well academically, he saw something in me and entered me into a host of competitions. So I did public speaking competitions when I was in year 9, and then regional and national mock trial competitions when I was in year 10 and then year 11. So by the time I was 15 in year 11, I had a decent sense that law might be something for me to look at, but not really any more than that. To keep my options open, I took a mixture of science, natural sciences and humanities at AS and A level. And as you'll know, during that time at sixth form, that's when thoughts turned to university subjects, and law seemed to tick all of the boxes for someone who was a bit of a frustrated scientist and liked the forensic problem solving of natural science, but also enjoyed writing essays and was okay at public speaking. I went on to read law at King's College London, and whilst I always had the bar in mind, if someone had said to me when I started uni that I'd end up practicing in London, I'd have been very surprised. Whilst I loved King's academically, particularly having tutorials and that sort of system, I didn't like living in London very much at all. But by halfway through my second year, two things had changed. Firstly, I'd somehow found myself with a really pretty Parisian girlfriend, and because there weren't too many pretty Parisians in Southport, when she wanted me to hang around in London, I kind of agreed to that. And then of more relevance for current purposes was the fact that I'd also begun to work out what I was really enjoying academically. And basically, I started to enjoy the subjects on my undergraduate course, which were a bit more technical and sciencey, things like contract, trust, property, and I enjoyed EU law too, actually. And I didn't really find with things like criminal law, which I expected to enjoy, that once I got over the novelty of the fact that we were talking about things that were in the news, there was an awful lot there of substance. One Sunday in my second year, I went into university, read into the university library, read Chambers Student, and made a list of all the subjects that I liked most and the best chambers in those areas. And I ended up applying for lots of mini pupilages at leading sets in those areas. And I thankfully got quite a few of them. And I came down from the Northwest in the summer between my second and third year, rented a room in not very nice accommodation, lived on Boots Meals deals, and did a string of mini pupilages at those sorts of sets back to back. In my final year at university, I applied for pupillage and somehow fluked into getting pupillage at a leading commercial chancery set with my first and only pupillage application whilst I was in my final year of undergraduate. So I ended up going straight from undergraduate law to bar school to pupillage. I think I was only about 20 when I got pupillage and about 22 when I started. Although clearly that set made a mistake because I wasn't taken on there and I had to do a third six pupillage, effectively, as Jess has already alluded to, a trial period at another set before I got tenancy, and then apparently became an actual commercial chancery barrister. So what do I actually do? I describe my own practice as chancery and commercial because, a bit like David, I do a mixture of both chancery work, although I'm probably more of a chancery lawyer than anything else, but also some sort of generic commercial litigation and stuff which is somewhere in between. And around half of my work involves working with other barristers, both in my own set and elsewhere in one capacity or another. And I was thinking earlier that today and this week is actually a pretty good example of my practice in a nutshell. Earlier today, I was in a directions hearing and a commercial arbitration about the supply of farming products. We represent a posh shop complaining that our farming supplier has stopped supplying to us and wants to go off and supply to someone else. And in that case, I'm leading a junior in Chambers. I then went on to start reviewing evidence in an unlawful means conspiracy case, an economic torts case, which has been trundling on now for 5 years or so. And in that case, I'm instructed alongside a silk and a slightly more junior at Blackstone Chambers. And that's because that case involves competition law issues and also company law issues, in particular, breach of fiduciary duties and associated equitable remedies. Later on this week, I have to do a skeleton argument for a commercial landlord and tenant hearing, which is happening next Monday. And I also have to write an advice on a property co-ownership dispute. And in both of the latter two cases, I'm acting on my own. In terms of what I might be able to assist with the questions, like Harriet, I'm heavily involved in pupillage. In fact, earlier today, I've been trying to work out with colleagues in Chambers who is going to be offered pupillage on, I think it's this Friday, having sifted and done the first and final round interviews for this year. As a pupil supervisor, I may well end up looking after whoever comes in. I've been a scholarship interviewer for the Inn for a long time, and I also sit on the scholarships and outreach committee and have sat on that panel for a long time too. So I'm fairly well placed to advise on what it is Chambers look for and what it is the Inn looks for with its scholarship applications, and they're not necessarily exactly the same thing. In particular at the commercial chancery bar, because as has already been stated, there is a greater emphasis on academic ability in our areas of practice than there are perhaps in others. around half of our applicants have a first. Around 60% have at least 3 A's at A-level. Bearing in mind, of course, there's an A-star grade at A-level now. And of course, I think we can only interview about a third of applicants at first round. So the competition is really fierce. And I agree with David that there's no point understating that or trying to kid you about that, because it does you guys no favors whatsoever to enter all of this on a false prospectus. It is hugely competitive, both qualitatively and quantitatively, and your grades do need to be excellent to have a chance of a first round interview. Beyond that, I'm not sure I can really add a great deal to what's already been said, and I'm conscious that we ensure we have enough time for questions. I'm also pleased to say that Mark has rejoined us, so and has given me a double hand wave to celebrate. So what I will do is pause my own introduction there and hand over to Mark. And when Mark finishes, Jess, we can move swiftly on to the questions.
Well, good afternoon, and what a joy and delight to speak to you all. I'm so sorry for the cutting out. I'm out in Kumasi at the moment. What do? I'm a barrister at Three Stone Chambers. It's a commercial chancery set. So what I do is banking and insolvency law. It sounds slightly diverse, but essentially it's the different ends of the same question. Banking is what happens if, and for insolvency, the question is oh bother, it's happened. I started my career actually doing something starting with a commercial first six, and then decided I wanted to try my luck doing a criminal second six. I'm much inspired by the TV programs at the time, and also to try and cut my teeth in court. Downside was I hated every moment of it. The clients weren't a bit like they were on the films or on the TV, and I then had to try and find a new home for myself. And finding a set which coming out of a top criminal set and trying to find a new home other than in crime proved slightly more challenging than I expected. I found a home in a tenancy in a common law set, and built my own commercial chancery practice. 10 years on, I got spotted by a deputy high court judge in a case and asked to join his set, and I joined what was then 13 L Square, and which became my present set, Three Stone Buildings. So the one message I would leave with you is it is difficult to move practice areas. So do try and see as many different areas of the law as you can. Do use those opportunities to get many pupilages, because really what you're trying to find is find your real home, find a topic you really love. And it may not be what you imagine is going to be your best choice first time. It's only when you try it out and see it for real that you get a real taste as to what's your perfect fit. What would I say about a practice? It is enormously grueling. There's massively long hours, many long lost weekends, missed dinner parties, missed school plays. There's an awful lot of overseas travel. One has to bear in mind 70% of the work in the commercial court involves overseas clients, and that also there's an awful lot of work which would take you overseas to do that. But the upside is besides the chance to live out of suitcases and have a crap internet connection, is that you meet some amazing people, because ultimately what you're dealing with is interesting problems, which bright people are found challenging and have got themselves into. What am I doing at the moment? I'm advising on a share purchase agreement. I've just spent some of this morning drafting my skeleton for a commercial dispute in a case in Dubai. Last week, my last bit of work was obtaining a validation order to unfreeze a footballer from a major football team, which I hasten to add was not Spurs, and to ensure that he has got access to his money. What do we look for from pupils? We don't tend to recruit first and second six. We generally tend to recruit third sixes. Pretty much everybody has pretty astonishing academic credentials. Pretty much everybody has a first, so that goes by the side. What we're looking for is somebody who's personable, somebody who will get on with clients and with other barristers. Somebody obviously who's good on their feet, but also a willingness to muck in, because this is as you will have heard from everybody else, an enormously demanding profession, but also an incredibly fun one. So I think I'll stop with that.
Great, thank you very much. Jess, perhaps if I hand over to you to pick out some choice questions. I've had a quick look at them, and I think you might be better placed than me to say which ones are particular relevance or
Sure.
particularly popular amongst our student base.
Yeah, I mean, so there's definitely been a couple of questions. I think we've got quite a few career changers
Yes.
in the audience, and so I think quite a lot of them are concerned or curious about how they kind of demonstrate, particularly in this practice area, that kind of academic rigor, particularly if their first degree was 20 years ago and maybe that wasn't a first. How you kind of say, well, actually, my professional experience has prepared me for a career at the bar, even if it's not legally related. So I wonder if any of you kind of particularly, involved in pupillage selection, how you view career changes, first of all. Do you think they're an asset? And second, kind of how can they demonstrate that? How sort of, I suppose, the successful ones that you've seen, either in obtaining pupillage or scholarships, or that you thought, yeah, they were good, even if they didn't necessarily get an offer of pupillage, what it was about them that helped demonstrate that.
Okay, well, I'm happy to kick off with that one because we have a few amongst our current applicant pool and have accepted a few in chambers over the years. Mark, sorry, it might be worth just popping on mute because every time you're moving, it's turning to you, I'm afraid. Thank you very much. The basic premise is that we're just looking for the people who will be the most competent barristers. We're looking for the people who will be the best at analysing legal problems, drafting documents, and going to court, broadly put. So there is absolutely no reason why that can't be a career changer at all. So there's no difficulty in principle with a career changer coming over. In terms of demonstrating, in particular, academic aptitude, I think panels are, or certainly should be, aware of the fact that degree inflation exists, and that a 2-1 in 2025 is not perhaps the same that it was the same qualification that it was 25 years ago, and so I wouldn't think that not having a first for a candidate who was at university some time ago would necessarily be as prohibitive a factor as it would if someone was graduating at the moment. So long as they were able to demonstrate intellectual excellence rather than, say, academic excellence in some other way. And depending on the job that they've been doing in the meantime, or jobs, plural, that they may have been doing in the meantime, it may be that those intellectual skills are really quite obvious. So it's not unusual for people to come over from banking or accounting, or we've had a couple of natural scientists apply to us. It's pretty clear if you're doing jobs like that you have a substantial amount of intellectual ability, even if you were at university 20, 25 years ago, or whatever the case may be. I pause there to see if the other members of the panel have any thoughts on this.
Yeah, I'm happy to go next. There are different stages of people transferring. I've seen some of the questions to this effect. You might get people who are a couple of years in being a solicitor and think, actually, I want to do something different. There, the reality is you're going to have to do the full pupillage process because the BSB won't grant you a waiver. Equally, you may have people who move having been a partner in a law firm. And one of my colleagues, he was a very successful partner, Travers Smith, but he wanted to do something different. So he came to the bar. He didn't need to go through the pupillage process whatsoever. And he's probably mid-50s. He came to us when he was about 50. You get other people who move careers dramatically. I mentioned we've got one pupil at the moment who's a doctor. He was maybe a doctor for the best bit of a decade. And in answer to some of the questions, yes, medic degrees may be marked slightly differently. But as Rahul has indicated, if you've been a doctor and you've been doing certain kind of things, you can assume that's a reasonable indication of intelligence, but it can be manifest in other ways, whether it's by research or other such things. We've also had people who've been journalists for a long time and then moved over to the bar. Lots of these are really useful skills. Lots of the skills that a journalist has in trying to hunt for information, constructing a narrative, that's what we do as advocates all the time. So a lot of these skills are transferable. Other people, someone I interviewed a month ago, she had run a business, run sort of 50 people, a company, successful company, then wanted something different again. She perhaps couldn't, her academic CV wasn't perhaps an orthodox one, but nonetheless, she said, this is what I've had to do. These are the things. I've been responsible for a £20 million business or whatever. So there are lots of ways that one can show skills that are relevant to what we're doing.
Great, thank you. I don't know if anyone else has any thoughts on this question before we move on to something else.
Hi, Rahul. The only thing I was going to add, echoing everything that you and David have just said, and I entirely agree with David that it's a slightly different story probably depending on where people are and what they're transferring, and what you were saying as well, Rahul. So the one point I was going to add is that if you're someone who is doing or is thinking about coming to the bar and needs to do a GDL in order to be able to get your qualifying law degree, then actually a relatively easy way of being able to demonstrate that you have the sort of intellectual or academic aptitude to solve legal problems is just by doing really quite well on your GDL. And the mere fact that you have done your first degree many years ago, and it may not be the result that you would have wanted, or was a sort of perfectly good result at the time, and the world has changed and now there's a sort of proliferation of firsts. The first point is that it's understood, as Rahul recognised, by those of us marking applications, that there are more firsts awarded these days than used to be the case. The second point is that if you do well on the GDL, then that is a pretty strong indication to the Chamber's marking or application that you have the aptitude to sort of solve and think about the law, which, as Rahul rightly said, is what we're ultimately interested in. The second point I was going to point out was really just to say that when it comes to, if you think about what Chambers are looking for, and I tried to sort of give you the headline of 3 or 4 key things, when you're thinking about answering your questions like why a career at the bar and demonstrate you have written and oral communication skills, someone who is involved in career changing is likely to have a career change, is likely to have a lot of examples that they can give to show, good written language skills. Often a lot of jobs that I see people sort of seeking to, when they're changing to come into the law, are able to give really good, clear, cogent examples of when they've had to deal with difficult clients or, do public speaking. So there is certainly opportunity there. I think just perhaps try to keep in mind what the bar is looking for, and then hone and tailor the way that you communicate, who you are and why you're wanting to do this job in a way that is effectively tailored to what Chambers and the bar is looking for.
Yes, Mark.
I think there are 2 things that a person transferring over can offer. Firstly, everybody's talked about the academics being shown by their job or their role, but there's also the actual skills that they've learnt or their profession actually offers. So in terms of, if so an accountant is who will have skill sets which are very relevant to our area of work in terms of insolvency and banking. A banker's a very interesting person for us, but it's because although they haven't been concentrating on the law, they understand the nature of the transaction involved. But there's also the second thing that's in play is that ultimately here we are running our own business, and somebody coming to the bar after a lifetime's career doing something else will have a whole network of potential clients, which somebody's coming straight from university won't have.
Thank you very much, Mark. Great. Well, unless anyone has anything else on that question, perhaps we can move on to consider another one, Jess.
Yeah, absolutely. I think there are kind of a couple of questions floating in there, and they're not unrelated to this kind of career changer question, but more broadly around kind of a degree from a non-Russell Group university, how that's seen, how people perhaps can make up for that, whether the sort of further study is an option. Someone has mentioned the BCL, for example, which is offered at Oxford, which is naturally a very expensive qualification, and so someone would need to consider whether it really is worth it, or any kind of further study is worth it. And so someone else has also mentioned sort of are certain GDL providers preferred by Chancery and commercial sets. So maybe we could talk a little bit about kind of the caliber of institution that is seen as respected, I suppose, by sets, and what people can do about that.
Okay, well, I can kick off on that one because I was, as you know, just asked a not dissimilar question quite recently. I think, and this is just my view, and I'll happily be contradicted by others on the panel, I think university institutions broadly do make a difference at the Commercial Chancery Bar, although the Oxbridge bias thing is, in my experience, heavily overstated. But there is a general preference towards first and high 2-1s, great grades from highly competitive institutions. So the way it was explained to me by a colleague in Chambers was I don't think anyone has ever been rejected for pupillage because they have a degree, have a first from UCL, King's, LSE, but you might, rather than Oxford or Cambridge, but you might be rejected for having gone to, say, London Met rather than having gone to King's, UCL, or LSE. So I think there is a general preference towards the more competitive institutions because there is an assumption, which in my own view is not unreasonable, that someone who has excelled amongst a very competitive cohort is probably a safer bet academically than someone who's excelled relative to a less competitive cohort. What someone can do who hasn't yet had the opportunity or has not yet succeeded in a highly competitive student cohort is to then do so or show evidence of excellence somewhere else. So I know that we look very carefully at people who have not gone to non-Russell Group universities at whether they've done any great postgraduate qualifications. I mean, Harriet's already alluded to the GDL. Let's say someone did a non-law degree outside the Russell Group but got a distinction in the GDL. That would weigh very heavily in their favour. You've also mentioned the BCL. We have a very junior tenant in Chambers who did her undergraduate degree at Brighton, which is not close to the Russell Group particularly, but she did very well on that course and got on to do the BCL at Oxford and ended up getting pupillage and tenancy. And that BCL showed us that it isn't just that she got a first because she was at an institution where people didn't have great grades at A-level. She was capable of doing well in any academic context. She really was exceptional. So there are ways you can show other evidence that you can be successful in a highly competitive environment, but generally Chambers will look for that because there is just such a crush for numbers when it comes to making that cut for the first round interviews. Once you get an interview, I can't imagine anyone really cares where you went to university, but it's about getting yourself through that paper cut in order to get yourself in the room. I'll pause there and feel free to jump in, guys.
Well, I'm of course the wrinkliest of people in the room, and when I joined the Chancery Bar Association, I had the distinction of being the only person on the list who didn't go to Oxford or Cambridge. It, from then and going forward, Oxford and Cambridge isn't essentially a bar to coming into the Chancery bar at all. But what you do have to do is to show that you're very bright, and that's the be all and end all of it.
Mark, David.
Yeah. The Chancery Bar, the Academic Liaison Subcommittee, we try and engage with these questions. We meet with various universities, not just ones which have been mentioned, to discuss, how we can better engage, what can be done. The reality is, though, that as we've said, you've heard the story of one of Rahul's pupils. That's not an atypical journey at the bar. I had a pupil, but he was first generation Bangladeshi, went initially to First University, then he did really well. Then he went to the BCL, then he did other things. But it doesn't just have to be the BCL. There are lots of really good postgraduates out there offered by universities within London in particular, but elsewhere too. So there is no one single pathway, is what we're all saying in slightly different ways, and we're all evidence of that. Because if you look at our credentials, they're all rather different, and our pathways are all rather different. And I suspect that's why we were approached in the way we were.
Thank you, David. Harriet, I don't know if you've got anything to add on this.
I wasn't going to add anything because I think the rest of you have kind of covered off what I was going to say, frankly. So I thought we could move to another question.
Great.
Yes.
All right, let's do that. Thank you. Jess?
Yeah, the only thing I would kind of add to the discussion is just that at the scholarship stage, again, we're not super concerned with practice area. We're not necessarily thinking too hard about that at that stage. And for our scholarship applications at the Inner Temple, we do sort of anonymize certain aspects of the application, and part of that is the institution, so the university, and we do ask you not to mention it as well. And so, that's partly because that kind of academic rigor, while important, is not necessarily the most important part of the application form. And so we kind of try to anonymize that there, because we're not necessarily experts, or our panels are not necessarily experts in kind of the differences between the degree studied from institution to institution. And as I say, it's not as important at that stage. So just to sort of point that out. And some chambers too, their recruitment will be blind in the same way. Again, I'm not sure how common that is in commercial and chancery, but that is something that you can usually find on a website where they're explaining their pupillage recruitment process. So if that's something that you're particularly concerned about, then I'd encourage you to sort of factor that into your research. Cool. So, and thanks guys for your honest inputs. I think it's really important to be upfront with people. Cool. So a few people have kind of asked some questions around how did you know that you definitely wanted to go down this path? You're interested in the law, but you're not super certain. I wonder if you guys could kind of touch on that a little bit, if anybody was a little bit undecided.
I've started the last couple of times, so I won't hog. If someone else wants to go first, then feel free to.
Yeah, I'm happy to. I've already touched upon some of the decisions I had to make: jurisdiction, location, area. As to why the bar, I think that's kind of something that had been at the forefront of my mind. I went to university rather naively assumed that most people studying law would want to go to the bar rather than being solicitors, and you learn that that's not the case. And again, there's no right, there's no wrong. The colleague I told you who moved from Travers Smith, he was seduced into academia, then got disillusioned with that, then became a solicitor, then ended up being a barrister. Lots of people move different ways, both from the bar to solicitors, from the solicitors to the barristers, and there's a number of reasons for that. Sometimes it's just to get different challenges. Sometimes it's the working environment and the things that Mark talked about, the long hours, the rest of it, the lost school sports days or whatever. That's not for everyone. And again, there's no value judgments involved. You just have to be aware of what this does entail. Those of us who worked over the bank holiday weekend, etc., etc. That's just things sometimes arise. There are other benefits as well, otherwise we wouldn't stick at it. But it's a question of, weighing up what you want to get out from what you're doing and what attracts you. And as I said, that's why one of the benefits of doing a bit of a time in a solicitor's firm, doing a time in different areas of law, and then seeing the reality of what one is compared with the other. Some people come in and think that the reality of what they do is completely different to what it is. And that's eye-opening, but it's useful to do that, and then you're much better informed. I'll pause.
Shall I pick up this mantle then? So I was going to separate it into sort of two stages, having looked at the question, because I think there's sort of two limbs to it, in the sense that the first part is, I think, a decision about whether to read law, if I've inferred correctly, and the other is sort of what about the kind of deciding to go to the bar. So I'm going to do the second first, i.e., how did I feel about sort of a career to the bar, and how did career at the bar, and how did I know that was sort of what I wanted? It was quite clear to me quite early on that the bar was going to provide what I wanted from a job, in that I wanted to spend my days solving problems, thinking, using my brain, and I liked the fact that I could do that at the bar, or at least I anticipated I could do that at the bar, in a way that would have some sort of impact on other people's lives, businesses, whatever it might be. So there was a sort of a point to it. You've been given the responsibility of helping to represent somebody else's cause, and to analyse and assist them with that. And I quite liked that idea, and I thought that was quite a useful way to spend my time. But it was really the anticipating that the career could kind of give me a way to use my brain that was the most attractive bit to it. And that perhaps is why I ended up doing really sort of chancery work, because that's quite a law heavy area that results in problem solving all the time. Now, having anticipated that was what I thought I would get from a career at the bar, I know that is what the bar gives to me. Now I do the job. So it sort of seemed clear to me in the beginning, and has only ever been confirmed by the doing. Then on the kind of second limb about reading law, you heard that I read law. As it happens, in retrospect, I probably would have read something else if I'd realised that that was sort of doable, as long as you got kind of good results and did well on the GDL or an accelerated 2-year degree, law degree afterwards. And I think so. I would say that, and perhaps others will disagree, that if you're stuck at the kind of earlier stage of do I read law or not at university, bearing in mind that I think I want to do a career in law, don't feel you have to read law. Secondly, I think it's probably a good idea to do something that you think you're interested in and good at, whether that's law or not. I cannot even begin to tell you how many people we have in chambers who were non-lawyers originally. I think it's about 50-50 when we last looked at the split. The people who read non-law have then done genuinely a variety of things. We've got sort of medieval history people, modern history people, classicists, PPE graduates. We've got a chemist. I'm pretty sure we've got someone who read straight economics. I think we have a mathematician last time I looked. I mean, it's a real mix of the English. We've got a few English people, English degree people. Last time I looked at this, it's a real mix. So I would say if you're at that earlier stage thinking, I think I want a career in the law, but I'm actually not sure whether I want to read law, then don't feel you have to go and do it. Go and do something else that you're interested in and excel at that, and convert to law later if you think you can fund it and all of those things. And if you're thinking of doing the GDL in the end, then just be aware that, as Jess has pointed out, there are GDL scholarships which several of my colleagues were awarded because they're members of Inner Temple when they converted to the law, and that helped facilitate them to where they are now. I hope that's sort of helpful a little.
Great, thank you. I don't have anything else to contribute on that one, I don't think. It's all been covered off. So we could perhaps move on to, I don't know if, sorry, Mark. I don't know if Mark does. Forgive me.
Only that for me, the choice for the bar is one of the great attractions was that I was in business on my own account. It's not a career for somebody who wants to get a salary. It's not a career which, certainly at the outset, you have much degree of financial stability. But for me, it was a chance. For me, it was important to kill what I eat, and the chance to be master of your own destiny is quite an alluring.
Great, thank you. Right, okay. How else might we help?
I've got someone's sort of asked a question, I suppose, around the risk versus reward. So they would be completely reliant on scholarships to pursue this career. Do you think that attempting to become a barrister is worth the risk, sort of in the modern day? Big question, and I'm sure like a personal decision as well as it goes. So yeah, I don't know if the panel have any kind of thoughts on that.
Well, I was in a not dissimilar situation. I mean, I did law as an undergraduate and then applied for pupillage when I was still an undergraduate because it was the cheapest way to possibly do it. And even though I got pupillage when I was finally an undergraduate and could draw down my award, that only covered the bar school fees, and my living expenses were covered from a scholarship at Inner Temple. And had that not happened, I probably wouldn't have become a barrister. The reality is that it doesn't really hurt to apply for things and give yourself the option, if you are offered places, to take them up. And there is an awful lot of support out there in terms of the in scholarships. You've already touched on them, Jess. We're the most generous in terms of the total amount and the total amount of major scholarships as well. But also, I think every commercial chancery set, I'll be corrected if I'm wrong, the ones I know of offer pupillages to people who haven't done the bar course yet and enable drawdowns during the bar course year to help with that funding. And something that we haven't touched upon, perhaps because it's too gauche, is that our pupillage awards are amongst the highest at the bar. In fact, if you look at the league table, I mean, they're all, I don't know what ours is now, 75, 80,000 pounds. I suspect Wilberforce's might be slightly more, Outer Templ's might be in that ballpark. They're really well remunerated, and there'll be a substantial drawdown for that bar school year. And that is really something which is fairly unique to our areas of practice. And so if you have the talent, and that talent manifests in different ways, but if you have that talent and it's identified early enough, then Chambers and the Inn will be there to support you. And then it's about whether or not you want to make those applications and put yourself through the ringer of pupillage applications or not.
Anybody else have anything to add? I think we're all pretty much on the same page on that one. Okay, cool. So yeah, I think it was helpful. The pupillage drawdown, I tend not to mention it in the presentation. I have it written on the slides, but mostly because it is really only a commercial and chancery thing where it becomes relevant. So yeah, where the pupillage award is sizable, as you say, is comparable to kind of your Magic Circle training contracts and that kind of thing. And that is in part, to attract the top talent as well. So that is important to consider. I strongly recommend, if you are a law undergraduate and you're going into your final year as of this autumn, go through the pupillage application process. Even if you're not confident necessarily that you're going to get an offer. I think going through the process as early as possible is important to get a better understanding of it, to get a better understanding of yourself and how you might perform under that kind of pressure. You know, you don't have to do the bar course straight after finishing your law degree. You know, more and more, as has already been touched on, people who are getting pupillage are older and older, and that is because they're taking the time to get the experience necessary to both, you know, get that offer of pupillage, but also to build a career and a practice at the bar. Like many things, you know, being a barrister is a vocation, right? It's like being a doctor, it's like being a midwife, it's like being a teacher. Yes, they're different things, but sometimes coming to it with more life experience and work experience makes you a better practitioner. And so that is important to consider, and that perhaps winding route to the bar is not something to be ashamed of, and not something to shy away from either. So getting that kind of practice in terms of applying for pupillage, lots of people will put off the bar course until they know it's a sure thing that they've got that pupillage offer. So that is something to consider. You know, there's a lot of pressure now if you're 21, you're at university, to what are your next steps? You know, what are you going to do? Maybe you get that pressure from your parents, maybe it's just from people around you. But ultimately you're going to be working for a really, really long time. So, you know, there's no necessarily need to get into your one and only career at 21, 22. So that's something to consider. So someone else has asked sort of some of the challenges that are unique to the commercial and or chancery bar. So they've talked about for entering, and I think we've kind of covered quite a lot of that. So the thing I'm quite interested here a little bit more is sort of the unique challenges of practicing at the commercial and chancery bar, perhaps that you're facing in your own practice, or things that you anticipate becoming challenges as well. Perhaps the panel could speak a little bit to that.
David, Mark, do you want to go? I was going to suggest. No?
Shall I go in terms of the sort of challenges? One wants to find areas of law that will sustain one through one's life. Now, there will always be dodgy businessmen. People will always go insolvent, etc., etc. Other areas are more brief. Something as a niche as film finance was really quite a sort of brief blip on the horizon. Pensions is a really good example, because until the 1980s, 1990s, pensions litigation didn't exist. And then there was an explosion. We are now on the long sort of tail, for reasons I won't bore you with now, of that. The question is how long that will last. Now, I know people who jumped from my chambers to somewhere in Lincoln's Inn 25 years ago because they thought the bubble was going to burst. Well, the bubble was quite buoyant for a long time, but undoubtedly some areas work will slow. Property work, well, notwithstanding COVID and changes and things, Harriet is still as busy as she's ever been, etc., etc. So you've got to, and one of the best things to do is to find different areas of work that complement one another. So, for example, insolvency and property is a really good mix, because one is counter-cyclical to the other in terms of the general well-being of the economy. So it's doing things like that. And not of this can always be predicted. Sometimes things change dramatically. The Russian invasion of Ukraine had a big impact on lots of people doing works for oligarchs. You then have to find something else to sustain you. Other things, climate change work, for example, didn't exist for obvious reasons. Lots of work in that area will grow. So it's being alive and astute to these things. And as I said, you know, some of the opportunities come your way. There's a mixture of luck. Sometimes you just happen to be the one person around in August who takes the telephone call. It's very difficult to predict how these things pan out.
Mark, I don't know. I think Harriet and I are trying to palm this up on the more senior.
I have a similar experience. I had the sort of lucrative but happy niche of cross-border mergers, and then Brexit happened, and that sort of, and a great chunk of my income vanished overnight. But at the end of the day, what one has to bear in mind is one has to keep enough breadth to your practice to have things to replace areas of practice that disappear because of things that you can't control. Also, I was listening and nodding sympathetically.
Well, I was actually thinking I might add something just to, which I think perhaps echoes what Mark has just rightly pointed out and what David was saying rightly too. So we have tried to sort of capture what the difference is between Chancery and commercial work, and I say this as a domestic land lawyer, which it really is a sort of, it's one bit of the sort of Chancery commercial spectrum. What I can see from being in chambers with people who have that broader Chancery commercial foundation to their training, and then also, their work, is that there are some people in my own chambers who specialise in maybe one or two of my own chambers' practice areas. There are others who have a much broader practice because, and this picks up on David's point, because their practice is unified by a kind of concept that covers lots of different areas of what is broader Chancery commercial work. So what I was going to say is, I think if you're thinking about Chancery commercial, yes, how you sort of specialise within that over time might be because of some case you get or a reputation you build in a particular field. But I was going to say that by going to that area of the bar, you potentially provide yourself with a great opportunity to remain quite broad and to be able to move between areas of work that evolve out of geopolitical events, regulatory changes, etc. So suppose that you're someone who does quite a lot of essentially fiduciary related work. That covers a lot of different areas of Chancery commercial law. And many of my colleagues will do a mixture of, it will be, the cases will sit in different practice areas on one analysis, but actually fundamentally they're doing work that kind of has those concepts at their core, and so they can pivot. And that's actually a great opportunity that comes from Chancery commercial, I would suggest. So maybe a slightly different take on the question, but there we go.
No, I agree. And just to I think pick up on Harriet's first point, one of the virtues and also the difficulties of some types of Chancery / commercial practice is that you have to be across, or at least be able to identify different types of legal problems that arise in commercial settings, because you can very easily start off thinking you're dealing with, say, a property problem, and then, as David has alluded to, it's actually an insolvency problem, or you think you're dealing with a commercial law problem and it's actually a company law problem. And to be able to, or worse, a tax law problem, in which case someone else will have to deal with it. Those overlapping areas mean that you have to know a lot of law at any one time just to have a working knowledge of what you don't know. And for those of us who enjoy law, and like Harriet, I was an academic lawyer, that's a great thing, but it's always a difficult and stressful thing. And the second point I'd maybe add is as to the work-life balance. You can't dictate when your opponent gets in touch with you in litigation. You can't choose whether or not the solicitors on the other side decide that they want to write a 30-page letter to you on a Friday evening when you've got a holiday booked. That's something which is fairly unique to commercial Chancery litigation, and less of a risk if you do employment law or personal injury. And it really does put stresses on not just, of course, yourself, but the people around you, particularly for those of us who have families or who are in relationships or have dependents of any kind, for that matter, because sometimes you're the only person who can feel that problem. So that is a unique challenge, I think, or a fairly unique challenge to our areas of practice, and one that has real and frequent resonance, I'm sure, for all of us in our lives.
Just chipping in, there is one certain litigant, which is the government department, which, as a matter of principles, always serves on Christmas Eve.
Yeah. Cool.
Nods from all the panelists there. Okay, great. Thank you, guys. So we've had a question a little bit more specifically around kind of AI in commercial and chancery law. I don't know if maybe we could do like a brief answer on that. I personally find AI quite dull. And there are some other questions in the chat as well that I would like us to get into. But just in terms of like, I mean, maybe it's just the bottom line of, do you think your jobs are under threat? I think, right, that's what most people are worried about. Yeah, Harriet says no.
No, but they will change, is the short answer.
Yeah, I agree with that, for what it's worth.
I think I'm perhaps slightly more worried than Harriet and David. I think if you look at the spectrum of what barristers do, from on the one hand, you've got a criminal barrister speaking to a jury trial, and to the other hand, you have a tax lawyer who is advising on black letter law. It's the latter which is probably most vulnerable to deductive reasoning from a natural language processor. So I think that, yes, I mean, I don't think we're going to become extinct, but I think some of what might be regarded as the bread and butter for very junior people, sort of fairly common types of pleadings and legal research, will get swallowed up within 10 years, actually, by advanced AI models. And it may be that we become more courtroom advocates than analysts in the future. But I think the core of the job, both analytically and in terms of advocacy, will not go away. But I do fear that some of the more basic types of analysis that's currently done by very junior members of our chambers is going to be vulnerable, in 10 years or so. Yeah.
Yeah, I think we have a vulnerability, but having been at the bar nearly 30 years now, we get promised the end of the bar with great regularity for very many different reasons, and somehow we're still here and making a crust.
Thanks, guys. Yeah, I think that all makes sense to me. So we've got a couple of questions around kind of sort of where to start, maybe around sort of further reading. If you're, if you think you might be interested in commercial law, but you're not really sure where to look, and then also sort of wider reading around building legal reasoning skills as well. So slightly two different kind of topics, but I wonder if anybody has sort of these things where you think every pupil I've ever had, I've recommended them this writer, this text, this case to kind of look over, that you think is sort of the essential guides, or just something that would be really important for them to consume.
I think we all grew up on Glanville Williams' Learning the Law, which is actually a pretty good sort of overview of the legal world.
I would recommend a book I reread recently. It's an interview of Lord Newburgh, former President of the Supreme Court, by Peter Riddell, I think a public servant, let's call him that, so I don't have to misdescribe exactly what he did. So Riddell and Newburgh, it's about 60 pages long. You can read it in an hour, but it's very, very useful way into understanding the different areas of law, the challenges to the judiciary, the rest of it. I think in terms of, bang for your buck, doesn't cost a lot of money, and you'll get a lot out of that hour or so you spend reading it.
There's a really old book by Eddie in Derbyshire called Eddie, E-D-D-E-Y, and Derbyshire, Derbyshire with an A, on the English legal system, which is a really nice intro. I think it used to be sort of prescribed reading for those who are thinking of applying to certain types of undergraduate law schools, but it's actually quite good even for people who are contemplating law conversions as an overview of how our legal system works and where different areas of practice fit into it.
Yeah, I found the title of the book, it's called The Power of Judges, which hopefully you'll remember and take away. And it is really quite eye-opening.
I'm not going to add to your reading list, because I think they're all really good suggestions. I was just looking at my shelf, which is why I was glancing sideways to see if there was anything in particular but I've got some pretty weird things up there that I've just read out of curiosity over time that are all quite interesting, but would mean that you'd end up reading all sorts of things about the philosophy of language. So I might spare all of you those things, but they're very useful when you come to start thinking and reasoning, you know, thinking about logic and philosophy.
I've had on previous panels people recommending speechwriters' texts. So I think someone said maybe Blair's like speechwriter wrote a book, and people kind of recommended that. Again, it's maybe a little bit more relevant for those who are looking to do that kind of courtroom advocacy. But I think in terms of constructing a compelling argument, doing it in the written form versus spoken, right? The similar kind of persuasive methods apply. So that is something to consider as well. Yeah, that other people have kind of mentioned to me. Again, more for kind of family and criminal practitioners, but something to kind of consider. Advocacy is still a really important skill, even if you're not standing up in the courtroom necessarily. So taking a little bit of a switch of topic, I had a few questions about kind of how you actually sort of build your practice, how you develop a caseload, how that kind of works. So how the relationship with solicitors or firms typically develop, and kind of how that happens, particularly for juniors. So I wonder if someone could kind of speak a little bit to that process, and perhaps the role that your clerk or clerks plural would play in that process.
Do you want me to go? Okay. So few things. There are some quick wins here. The first quick win is do good work, as in do your work well, and deliver it on time. And delivering it on time doesn't necessarily mean that you have to deliver it to a completely unrealistic deadline on every single occasion. That sort of thing can be managed in conjunction with your clerks. But if you said you're going to do something, do it well and do it on time. That will go a long way in terms of developing good relationships with solicitors early on. Because let's face it, in our area of work, what they're actually looking for is someone that they can rely on, who's going to do a good job, and they're going to be there when they need them. So that sort of element of delivery and sort of responsiveness and dealing with stuff is a huge component of how you build, or how one will build a practice in our area, I would suggest. The second, so that's the kind of quick win, which is entirely within your control. The second aspect is sort of clerks, and this will differ sort of chambers to chambers, but the fundamental will be the same idea, which is that the clerks will have relationships with particular solicitors and particular firms, and they will continue to develop and nurture those relationships on behalf of chambers, in the sense of on behalf of each of the individual barristers within that set. And that work will come in. If it doesn't have a specific barrister's name on it, it's sort of regarded as unallocated work. The clerks then distribute that in accordance with usually a fair allocation of work policy. That's certainly the case in my own set. And then as the individual barrister, the bit you then control is the sort of the delivery of that piece of work that gets given to you through that kind of chambers firm. So the clerks and the barristers are kind of working together, but the bit that you really get to handle is sort of the content of the work. And I would say time and delivery is the kind of the key thing. Then alongside that, as time moves on, you will develop sort of ongoing relationships with solicitors with whom you work frequently. You will become really quite, often quite friendly with solicitors who you've worked with frequently. And so over time, you will start to build a rapport and a relationship with the solicitors for whom you've sort of hopefully been doing a good job and sort of happily been working with over years. And that, how that is done is different for each barrister, in my opinion. I'm not a huge lover of big barrister parties with clients, as it happens, but I'm perfectly content to go for coffee or sort of small groups or like little lunches or something that end up being like part of that relationship building around the edges and outside of your work. Some of my colleagues will go to parties. Some will build relationships by going out to firms and delivering lectures. The way those relationships are developed and nurtured does look different for everybody. And for my part, at least, I think that sort of is a bit personality dependent and is a bit based on you finding your own way to sort of nurture those relationships. But I really would emphasize that at the outset, the most surefire way of getting repeat work is do good work and do it when it's needed.
Yeah, I think there's only 4 people you have to impress in our job: your clients, your counsel team, your opponents, and the judges. If you do that, you're well on the way to doing well. Some areas, marketing is more important than in others. And I see that in my chambers, perhaps because we have a wider range of work than elsewhere. Some people are more naturally suited to some thoughts of marketing than others, as Harriet said. But generally, to begin with, work will come in either to chambers and then will be distributed, or will come into leaders who want juniors. And if you've been their pupil and you've done well, that's your impressing chambers thing. With time, work comes in either specifically for Mr. Watson-Gandy, Miss Holmes, Mr. Varma, or it comes in for 3 people. And you're then bidding against potentially colleagues in chambers or people elsewhere. And you don't know sometimes exactly the process that goes on. So it's a strange process, but those should hopefully give you some insight into what is involved.
Yeah, I agree. The only minor point I'd add to all of that is after a certain period of time, yeah, I mean, your chambers might well be ranked in the directories, the legal directories, Chambers and Partners, the Legal 500 principally, and you might be as an individual, and that then is another public profile which can help attract work. Great,
thanks, guys. Sort of, I suppose, following on a little bit from the book suggestion from Reading Corner, also had someone ask what are some interesting cases in corporate and commercial law, and we don't necessarily have to go around and answer that now if you don't want to, but it's a question in the Q&A, so each of you should be able to type an answer to it if you have one that comes to mind, that people can just kind of Google and research themselves on their own time, and that would be great. There is a separate question, totally off the topic of books. What are the key differences between the work of a commercial solicitor at a major city firm and a commercial barrister on a day-to-day basis? Yeah, wonder if anyone could go on that. Mark?
A commercial solicitor will be part of a large team. The barrister will be brought in as an individual, a hired gun for maybe some small part of the work, maybe some issue which the solicitor's firm takes the view that they don't want, they'd like to be running on somebody else's insurance, so they'll take advice from you because as regards that potentially problematic issue. The solicitor will be involved with the case from the start to the finish. You will be brought in at odd and exciting moments during its life. But the primary difference is you are on your own, or you might be leading somebody, but by and large you'll be on your own. Solicitors will have a team working together.
How common is it that actually it's a KC who's assigned to the case and then has people working under them? How often does that kind of happen in this area?
By and large, the KC will be brought in for at the end for the last bit. Or if you're a leading junior, you will bring in a junior counsel to help you for the heavy lifting for when it comes up to trial.
we have a KC on the team who might be able to answer that.
Yeah, but I mean, not necessarily. Sometimes offered. I mean, it's really important to see at all the different levels as to people's perception of it. But the reality is, because quite often there's a lot of money at stake in some of the cases in this area, you will have bigger counsel teams than in other areas. So, for instance, lots of employment tribunal work, most of it is done by a junior. Not all, but a large proportion. So one of the case I mentioned, the enforcement case, the first appellant has 2 silks and 2 juniors. My team, I'm leading 2 juniors, and the respondent have, I think, if you include an academic, 4 silks and 2 juniors. It's complete overkill, but it's sort of, fighting the good fight and impressing one's clients, especially their international clients, and ensuring that they perceive there to be an equality of arms.
Yeah, I mean, for what it's worth, the cases I've been involved in, which have involved silks, have generally had them in from a really early stage, often on the pleadings, because the solicitors will want that sort of badge of approval before a case gets issued. So the case I mentioned at the outset, which I've been working on for 5 years or more, the silk there has been involved all the way through, because they often want an advice on merits from the silk before the matter proceeds. And I don't think that's that uncommon. I get the impression certainly all of the other parties in that litigation have silks on board and seem to have had silks on board from the pleading stage at least onwards. I mean, Harriet, I think it's a similar experience for you, isn't it?
Yeah, absolutely. And on the sort of distinction between, I mean, I'm not sort of, I don't regard myself as a commercial barrister as it happens, but just trying to unpick the distinctions between like what the job looks like. And it may be that some of you listening think, oh, well, she would say this, but there is some truth in it, because just to give this context, I quite often end up marking the applications of people who've worked in major city firms and worked as commercial solicitors who are absolutely desperate to come to the bar for this reason. So one of the distinctions on the day-to-day can look like this. We get to deal with the difficult problems and to analyse the law much more often than anyone sitting on the sort of law firm side of the team. If it's a difficult problem, off it goes to counsel, typically in anything that is a sort of commercial or chancery litigation matter, even on sort of difficult questions that arise in on an advisory basis in prospective transactions or the like. Off it goes to counsel. And so I think quite often one of the things I suggest to those looking to come into questioning whether to come to the bar is to sort of ask yourself this: do I want to kind of use and analyze the law as part of my day job, or am I sort of quite happy farming out those difficult problems for someone else to look at and advise on? And both answers are the right answer. These do not have to be, this isn't a value judgment on anybody. The two jobs are absolutely essential. Otherwise, that we're all part of a team. But you've got to ask yourself the question as to what you want to do. And the answer was always very clear to me. But yeah, I otherwise agree with Raoul that I mean, it varies. Sometimes I will have worked on a case and a silk comes in later, more often than not, on the kind of silk point. In fact, actually, the thing I was looking at this morning, one of the things I was looking at this morning, the silk had done the pleading on his own. Then a junior was brought in, and basically I will now run it for a bit. And then there'll probably be a sort of he'll come back in at various stages if they want his input on, say, expert evidence or something like that. But yeah, I agree with Raoul about that aspect of what we were talking about.
Yeah. Can I just say briefly, in terms of the difference between solicitors and barristers, people transfer from solicitors to barristers for different reasons. But I bet that in 90% of the cases, it's either to do more law or advocacy. That's the motivation. That's the distinguishing things.
Yeah.
Even those in law-heavy areas, harking back to my colleague, the former academic, his motivation was that he said, "I want to do more law in a law-heavy area, and I want to advocate."
Yeah.
Great, thanks, guys. I think sort of just to wrap up, we've had a couple of people ask kind of what's the difference between between corporate law and commercial law, and I don't know the answer. So I would like one of you to. I'm not really sure that we would necessarily use those terms, but yeah, go for it, Mark.
Corporate law is more my area. It's corporate law is companies. Commercial law is contracts. But like just like with Chancery and commercial, there's an overlap. And when you think about the way that people organise their affairs, there's going to be.
Yeah, tends to be more of an American term. I think we tend not to just talk about going into corporate law quite as much. It tends to be, as Mark rightly notes, basically companies work, and in particular transactional companies work, rather than litigious stuff.
Yeah.
Greater chance for having all-nighters.
On which side?
Oh, on transactions.
Okay, right.
In fact, it's obligatory, as far as I can see, for the team on both sides to insist that the transaction is necessary. It's necessary to work until the following morning and send out for clean shirts and pizzas during the night to fuel you through it. Having done a couple of those, I convinced myself that if ever I was sitting in a position of power, and I would be able to, I would tell my lawyers that they should never should stop work at 5 o'clock because there is nothing that you write between the hours of 2 and 5 in the morning that won't get you sued. I chaired a company when many years later, and we were about to get finance in, and I said, look, it doesn't matter when this deal is done. We can do it tomorrow or the day after that. Just get the documents done properly. But I kid you not, they insisted. They somehow or other the lawyers insisted on doing an all-nighter.
Jess, Raoul, can I rather cheekily try to sort of pick up on a question that I'd sort of looked at and we haven't quite got to it, which is the sort of whether there's one thing that all successful pupillage interviewees have that we can all identify. It might be that we all say slightly different things, but I have thought about this over the years of me interviewing to try to understand what it is that seems to. It used to frustratingly be described to me by others as like, oh, they've got it, and you'd sort of think, what on earth is that? What I think is this: what the candidates who are at least successful in the interviews at my set have in common invariably is a clarity and flexibility of thought and mind. Now, what on earth do I mean by that? You can almost see when they're thinking about and answering something, their brain working to sort of have thought through the various permutations of the sort of the problem or the question that they're being asked, and then they're able to use the advocacy experience that is referred to by the person asking the question to then explain clearly and succinctly what they think the answer is. But then they can also adapt their thinking when, for example, as is invariably in the case in lots of these interviews that deal with legal or ethical problems, the facts are changed or shifted by the people asking the interviews. And this is where the flexibility of thought comes in, because they've thought clearly enough and have the clarity of thought to be able to reason. They then have the advocacy experience to then answer the question clearly and well. They then have the flexibility of thought to then have a new fact introduced or something slightly changed, and they kind of rework the problem and then do the same thing again and give you a nice, clear, clean answer. And the only way I've ever been able to try to explain what that is, as I've said, which is this clarity and flexibility of thought. They're sort of doing the A to Z analysis whilst at the same time thinking, but if this happened, what, you know, how would that sort of change? And it does seem to be the common thread, at least people that we've recruited in my set.
Yeah, I think that's really important, and I agree with it. In our area of practice, you can't really be an effective advocate without being an effective analyst. So clarity of thought leads to clarity of expression. Importantly, Harriet didn't say we look for confidence, because we don't want used car salesmen. We want people who are genuinely capable of seeing the wood for the trees, commanding detail, but retaining that ability to focus on what's important. That can come from a very shy, softly spoken person. It can come from someone with a non-traditional accent. It can come from anyone from any background. They just need to have that talent in what is a competitive pool.
Completely agree, for what it's worth, with the Burrell's addition there. I think that's really important.
Yeah. Can I jump in briefly? I can't improve upon what we're looking for, but can I show you why it's important? Because I think the best barristers, and particularly the best advocates, cut through the mass of material that's in front of you to say, these are the key issues, and they present it in a way to the court, so the court can see the logic and the attractiveness of what they're saying. And if the court isn't with them, the court say, but Miss Holmes, what about this? Then Miss Holmes will say, well, okay, I will adapt my answer, and here's an alternative, which may satisfy them. You can't be overly committed to one argument, because the judges may not like it, but with the slightest variance, you then get them back on side.
I think it was all, yeah, really helpful. Thank you, guys. So we are kind of up at 8 o'clock now, and we've all got, you know, evenings and dinner, hopefully, to get to. So sort of just on me really to say thank you very much to our panelists for their contributions and for giving up their evening. I have put a link to our feedback form in the chat. If you do just have 30 seconds to complete that, that would be great. This event was recorded, so we'll be circulating the recording tomorrow late afternoon, and I'll try to pop some sort of other helpful links in there to some upcoming events that we've got. But otherwise, thank you very much for attending, and yeah, enjoy the rest of your evening.
Bye everyone. Thank you so much, Jess. And
yeah, no worries.
Thank you,
Yeah.
Jess.
Very
Bye.
nice.
Thank you, everyone.
Enjoy your time, Mark.
Yeah, enjoy, Anna. Bye.